All right, everybody, welcome to Better Call Paul. As always, on behalf of Trident Title, Performance Title and Escrow, and Synergy Title, we have the esteemed Paul Krasker in the house. Today, we're going to be talking about wills and trusts, how to sell properties that are in wills and trusts. And at the end, if you do have any questions regarding wills and trusts, we will allow you guys to dive in and ask away any questions. So we don't really have a format set up on my end of it today. We're just going to let Paul kind of talk about it and share some of his wealth of information with us. And then anybody else that wants to jump in and ask some questions at the end or provide some examples can do that. So Paul, take it away. Let us know what we need to know about selling properties with wills and trusts.
Okay, I will try to talk for a maximum of 20 minutes and then leave time for people to ask questions at the end. Awesome. The goal of this Zoom, I don't know whether they're called calls or time periods or whatever, but we're Zooming now, and the goal is to get all of you to understand what the administrative process is if you're selling property after somebody passed away, either through a will or a trust, and what those pitfalls are, and so that you could be as knowledgeable and helpful to the people during their process as possible. So I'm going to start out by what is probate, and probate is required. It's a required court proceeding if somebody passes away with the property in their name, and it needs to be transferred to third parties. And you need an attorney to bring that through the court process. We do that for a bunch of you. Appreciate the referrals, and please think of us in the future. Let me talk to you about the different types of deeds that sometimes avoid the need to have probate. The first one is a tenancy by the entirety or husband and wife. So if a husband and wife own property and the wife passes away, all you have to do is record a continuous marriage affidavit and the death certificate of the wife, and the property will be in the husband's name. Same thing for joint tenants with rights of survivorship. So if a mother and a daughter own property together and the mom passes away and it says joint tenants with rights of survivorship, then you don't have to do a probate for the mom's estate. All you have to do is record a death certificate, and it will be in the daughter's name and she'll be able to sell. If the property doesn't have a designation after co-owners, it is deemed to be tenants in common. So if a mother and a daughter or siblings own property and it doesn't say joint tenants with rights of survivorship, then each party will have owned 50% undivided interest, and you will have to probate the decedent's portion. So if mom owned 50% and daughter owned 50%, and you forgot to put the magic words in there about survivorship, you're going to have to probate mom's estate before you do anything with the property. There's also something called a life estate deed, also referred to as ladybird deeds, and those allow properties to pass without having to do a probate as well. You transfer the property into a life estate for mom with the remainder interest to the daughter, and upon mom's passing, again, you just record a death certificate and the daughter owns the property outright. You don't have to go through probate there. And then obviously the other section that I'm going to be talking today about instead of probate is trusts, the sale under a trust. So you can always transfer the property into a trust before somebody passes away, and that will allow the successor trustee to sell the property when the original trustee passes away. You can identify a successor trustee and a successor beneficiary, and the trust can transfer that property outside of any probate requirements. Okay. Again, when do you have to file for probate? When the last owner of record passes away and there's no trust, when the last owner passes without a life estate deed, etc., Or you also have to probate when there's a trust, but that trust is being challenged or was improperly deeded in. I see a lot of people record do-it-yourself quitclaim deeds to trusts, and they don't refer to their marital status when they send it in, or they don't have the right legal description, or they don't have two witnesses. And for all of those reasons, you can end up having to go through probate, even though you tried to avoid it by recording a quitclaim deed into a trust. Okay, I'm going to talk about the three categories of probate administration. One is the summary administration. That's when you have homestead property or all of the assets are under $75,000 in value, not including the homestead property, or there's been 2 years since the date of death. And then you can file a summary administration, which basically means there's no probate creditor period, so you don't have to notify creditors, and the whole thing goes much quicker. You also don't even have to appoint a personal representative. You could just identify the heirs and transfer directly to the heirs. The second type of probate is when there's larger assets involved, and that's called a formal administration. You do have to open up a creditor period, but the great news from your perspective as realtors, you don't have to wait until the creditor period expires to sell the real property. You can go ahead and sell the real property in advance of the creditor period, as long as you hold the net proceeds in escrow during the creditor period. So the probate beneficiaries don't get their money until after the creditor period expires, but you can sell the asset, and especially with hurricane season looming, it's something that you want to get done so you don't have to continue to pay taxes, insurance, mortgage, have the risk of loss in hurricane season, etc. Let's see. The third type of probate is called ancillary probate, and that is if there's an active probate in another state or another country, and you're just doing a small probate down here to sell real property within the state of Florida. That's usually less expensive and about the same time commitment as it is to do a summary administration. Okay. I get a lot of people at this point who start asking me questions about probate proceedings and who can act on behalf of somebody, and they get confused between a power of attorney and a guardian and a personal representative. So I want to explain each of those terms. A power of attorney is a document that can be signed by someone giving a third party the right to make financial decisions for that person. So if my mom wanted me to step in and be her power of attorney, I would be able to write checks for her. I would be able to buy and sell real property. I would be able to mortgage real property on her behalf, but I would only be able to do so during her lifetime. And if my mom got to a point where she wasn't lucid or wasn't capable of executing a power of attorney and she was still alive, then I would have to go for a guardianship over her person and her finances to be able to control the real property and sell that to third parties. So that's where a power of attorney and a guardianship can act only in the case of a person still being alive. Once that person passes away, a power of attorney and a guardian have no rights whatsoever. At that point, you have to have a personal representative step in who's either appointed under the will or appointed under the statute if there is no will. A family member, blood relative, an attorney that has the consent of all parties, something of that nature. Okay. Here's the big one for all the realtors to understand if you're dealing with a probate proceeding. I get calls weekly. Who do I need to get to sign these documents? Number one, you've got to figure out if there's a will or not. And your client who's talking to you needs to know what it says under the will. You also have to figure out if this is homestead property. If this was the property that that person lived in up until the time of their death, or shortly before their death, if they went to a hospital or rehab facility but had the intention of coming back to the home, if that property is homestead property and there was a surviving spouse or minor children, then it cannot be devised by a will, period. It goes to the heirs at law. And so even if there is a will, if they had a wife, they had husband, wife, and they had minor children, it must go to the heirs at law. If there's no will, then again, you use the statute to determine who the heirs are. If there's a spouse and children from a previous marriage and this marriage, it's different than if there was a spouse with children from the same marriage, or a spouse and then children from a second relationship, etc. Those are all treated differently. But the key is to understand if it's homestead, you go in and you ask for an order determining homestead, and once the homestead is decided, they identify who those heirs are, the property is transferred to those heirs, and then those heirs sell the property to a third party. If there's a will and there are no minor children and there's no spouse, then in your will you can transfer the property to anybody you want, and it's their property to do with what they want. They can either sell it from the estate, or they can take title and then sell it on their own. If there's no will and no minor children or no spouse, then the personal representative can sign those documents and no heirs will need to sign. But here's the tricky piece of all this. At some point in time, you could have a situation where there are heirs at law that need to sign quitclaim deeds, even though they're not getting any ownership in the real property. And that's the tricky time for you, because sometimes those people are bitter, they don't want to sign, they don't care about it, and they're trying to be disruptive of a sale because they get no benefit from it. Those are times where we need to know that up front. We need you to give us a heads up so that we can go into court as soon as we open up the estate and get a court order authorizing those heirs to sign quitclaim deeds back to the beneficiary, back to the PR, however we need to handle it, to get that deed taken care of before closing so there are no delays. So that's one of the times that we are partners in the deal, and we need you to give us a heads up. Okay. I guess that's almost enough about probate. I'll say a few last things. Number one, I want to repeat, you can sell the real property prior to the creditor period, even starting if you want. We just need to have a court order. We just need to know who we need to get consents from and whether or not it's homestead property. Scenarios to avoid. I get realtors who call me up all the time. Will you please do a quitclaim deed for my friend? She's elderly. She wants to add her daughter to the deed. Please don't do that. Please have them call me. I will explain the pitfalls of doing that. Basically, if you do that and then the elderly person dies, that young person who was on the deed with them, instead of getting a step up in basis when they pass, instead of that, they end up having to pay capital gains tax when they sell the property based on the original basis of the elderly person. So if a grandmother bought a property for $100,000 in 1980 and the granddaughter gets a quitclaim deed and then the grandmother passes away and then she sells it for $600,000, she's going to pay taxes on that $500,000 gain. If you did it as a life estate or an irrevocable trust, and had the same intention but structured it differently, there would be a step up in basis at the time of that grandmother's death, and the granddaughter would pay 0 in estate tax and 0 in capital gains tax. So sometimes the realtors who offer to assist and their name is on the deed, they end up getting sued when the granddaughter complains about having to pay all the taxes, and you find out that that it is something that should never have happened, and there should have been no tax liability on the sale. So don't put yourself in that situation. The other situation that I want to remind everybody, figure out early, is it homestead, is it not homestead property? All right, I'm going to jump on to trusts. Let's see, if the property is owned in a trust, you need to get a copy of the trust as quickly as possible. Don't sign a listing agreement with the son just because he says he's the trustee, he's the successor trustee. We had a situation down in Fort Lauderdale in a KW office where somebody took the word of the son, somebody got into contract with a purchaser, and they were beating up our closer. I eventually stepped in and said, you're either going to send me a copy of the full trust right now or I'm going to call the police. I just knew that this son was a bad guy and trying to defraud somebody, and it turns out he was trying to defraud us. He was not the sole trustee. He was one of 3 trustees, and his 2 sisters had no intention of ever selling the property. So the agent was in a lot of hot water and could have gotten sued, number 1, for a commission from the selling agent, but number 2, for damages by the buyer if they had to go out and find another property. So really make sure that you've studied the trust and that you get a copy of the complete trust so you know who you're supposed to deal with in signing the listing. Know that we're always open to speaking with you, always open to a free phone consultation at the up front when you're trying to put the listing together to make sure you have the right parties and the right scenarios. So please consider us your partner in this to get these things done smoothly and well in advance of closing. I think that's all to start.
Well, Paul, a lot of this stuff sounds more complicated than what most realtors are really looking to involve themselves in the scope of work. So how early do you suggest they contact you where it makes sense for both of you and it's not too premature? If they're going on a listing appointment at 123 Main Street, and when they talk to the seller, pre-qualifying them on the phone, and the seller says, it's a trust, or, dealing with probate, or, my elderly person in my family passed away and I'm dealing with it. Do you suggest they reach out to you first so they go in there, with a full tool belt, or go in there first and, build some rapport? What's the optimal strategy that makes it make the most time efficiency for you as well as the realtors?
A lot of agents tell me that it's too difficult to get the trust in advance of their meeting. They need to build trust with the person, no pun intended, and they need to develop that rapport that's going to get them the listing, but also get the other side comfortable that they're the right person to handle this and move forward. So if you need to talk to me in advance and you need to do a little research in the property appraiser's office to know how title is on the last deed of record, I'm happy to talk to you on the telephone, give you some general ideas and some general questions that you should ask. But usually when you go to PAPA, you can know, number 1, is it homesteaded? And number 2, is it held in a revocable trust and another type of trust, or individually that's going to require probate. So I can talk up front. If you do get those documents in advance of your meeting and you want to send them to me, happy to give people a comfort level that we know what we're doing, and we can move things forward.
Awesome. And that's available, guys, with Trident Title, Performance Title, Synergy Title. So all of you guys are on here, because of that. So if anybody has those things, definitely reach out. Another question that came in the chat: if a mother and daughter purchase a home with joint tenants with right of survivorship, can the mother who is residing in the home claim full or partial homestead?
Full, yes.
Full. Awesome. Anybody else on here? I know there was one or two other questions that did not have anything to do with wills and trusts. So let me do this first. Does anybody else have anything question-wise or anything that they want to ask or talk to Paul about in regards to selling properties that have something to do with a will or a trust?
I have a question.
Go ahead. Christina, is that you?
Yes, it is.
Go ahead.
I have a friend who has a small campground that they have 6 people on the deed. 4 of those people are dead. It's probably not worth any more than $10,000. Do they have to go through the whole probate process? And about how much will that cost him to get those 4 people off?
How is the deed created? Is it deeded as tenants in common or as joint tenants with rights of survivorship?
I believe it's tenants in common.
Ooh, that is 4 probates.
Ouch.
Yep. And probates, even at the lower level, and if there are no other assets, a summary administration still costs $3,500.
Okay.
So you're talking about 4 probates is more than what the whole property is worth.
What would they do in that case, Paul? Like if you were one of the 2 that was still alive in that case, in that situation with the other 4 on there, what do you do?
I would see if the other parties had already opened up probates because they might have had other assets, and if so, you could go to the personal representative and ask for a deed. So if you could get 2 of the 4 properties deeded back based on that, then you'd only have to do 2 probates. But the other option to do, and we're honest with people about it, even though it's not title work for us, is sell it to somebody else as a quit claim. Don't give them any representations or warranties. Just saying, hey, I'm transferring whatever I own in this. If it's a 1/6 interest, then you got the 1/6 interest. The other people are dead. They're not going to come back and pester you. Nobody's ever going to argue with you. Just treat it like it's your own, but don't think you're going to be able to devise it to your kids without headache.
Got it. Makes sense. I got 2 more in the chat here that just popped up. What was it about the homestead to know about the probate and trusts besides the taxes and protections? Not sure exactly. Alex, can you pop on and clarify a little bit there what you mean on that one?
Sure. You mentioned earlier, Paul had mentioned earlier about knowing if the property were homesteaded. I was just wondering what that was about. I know there's, taxes and other legal protections for homestead, but what exactly do we need to know about the homestead? If
Sure.
It's homesteaded?
So I can give you the background of why it's important. And it's really historical and it's really horrible to hear. But what was happening in the 40s and 50s when Florida was becoming more populated is guys were coming down here, they were married, and they'd move both their wife and their girlfriend down here. And before there were homestead laws, they would leave the property to the girlfriend. And so the guy would die and there'd be a funeral and the wife would come back to what she thought was going to be her home. And there's somebody else standing in the doorway saying, you no longer have occupancy rights here. This was deeded to me. And people society in general got offended by that, and they created these homestead protections that says if you're a spouse or a minor child, the other spouse cannot devise the property away from you without your written consent and knowledge. So there's a protection there, and that's why it's so important to know if there's a homestead. And even if there's no spouse or minor children, if there are adult children, and there's no mention of the homestead being transferred to anybody else in the will, it passes via the homestead descendancy to those adult children. Even if there are $50 million in creditor claims in the estate, those adult children take that house free and clear, other than any mortgages that might be on the property. They take it free and clear of all the other creditors. It doesn't go through the creditor period. It just gets devised directly to those heirs. So we give great homestead protection and care about that equity going down to the next generation and to the spouse.
Well, okay, so basically it's to confirm like who should be on the listing agreement, and are allowed to sell a home.
Correct. So if there's a spouse and a minor child, and that minor child is from another relationship, you're going to have to go to the spouse because she's got homestead rights, and you're going to have to go to the guardian of that other child, the baby mama, so to speak, so that both of those people are going to need to sign a deed if you're going to sell this to third parties. The baby mama on behalf of her infant child or minor child, and the spouse are both going to have an interest in that property. Both are going to have to sign off.
Oh, okay. So in that scenario, obviously the spouse that they're currently married to, and then if there's that child from another, the mother would have that right to sign that deed.
Sure.
Okay.
Exactly.
Because they're trying to act in the best interest of that child, securing that.
Correct. Because they're the guardian of that minor child that has ownership rights, that mom is going to be able to act on the child's behalf.
Makes sense. All right, a couple more. On the from the previous question with the daughter and the mother, how will the daughter be taxed when she has to sell the condo after the mother passes? So just to refresh, if a mother and a daughter purchase a home, joint tenants and right of survivorship, the mother is the one actually living in the house, the daughter is not. Mother claims full homestead and then mother passes away. What happens to the daughter when she says, okay, I don't want this house now that my mom is dead, I'm going to sell the house?
So she's going to get taxed. She's going to get taxed if they're joint tenants with rights of survivorship. She's going to get taxed at the basis of hers as of the date that they purchased. So if they bought for 100 and they're selling for 600, she's going to pay the 500,000 in capital gains.
Got it. Okay, rental scenario. Both owners, per the deed, just died within days of each other. A mother and a grandmother died and passed away, and the survivor is the daughter, or essentially the granddaughter in this case. The granddaughter is trying to rent the home before the home goes through probate. She has the death certificate. What else needs to be done to guarantee that the rental would actually be allowed? The daughter has a home already. This person has a home, so they don't need to live in it. So she wants to rent it to get some income while all this is going on.
Okay. She could certainly rent the property prior to the probate being opened. Technically, she doesn't have full rights until she's appointed as the personal representative. And she needs to know who the beneficiaries are. Both people probably need to know who the beneficiaries are to make sure that they're okay with this. because technically that's an asset of the estate, and technically the rent should be going towards the estate as well.
Makes sense. What is the difference between a revocable trust and an irrevocable trust? And is there any kind of a difference in taxes based on one or the other?
So a revocable trust is one that can be revoked by the person who granted the trust, who started the trust. And those are considered pass-through entities. So whoever the beneficiary is just taxed individually on whatever benefits come through the trust. An irrevocable trust means something that cannot be revoked. Those are usually done for one or two reasons. Number one, tax benefits. You're transferring the property now so that you could get a deduction. Sometimes you could take a discounted rate for the value of the property because you're transferring a minority interest. Sometimes it's a specialty trust like a Q-PERT or a Q-TIP trust, which are designed to save estate taxes. The other reason that people do irrevocable trusts are creditor protection. You know, some big shot finance guy from New York who's been defrauding people for years comes down here, establishes an irrevocable trust that buys a piece of property, and he sits in there, waits for the claims to come in the future, and nobody can go after this asset because it has creditor protection.
Got it. Gab wanted to add one thing and then sign off here, and then two off the air questions.
Paul, can you just talk about if they were to go to a listing appointment and the property is in a trust and someone is telling them they have power of attorney over the trustee, that doesn't fly, right?
Yeah, so you remember from past deals that we've had where people get very disappointed. You can have a power of attorney for a living person. You cannot have a power of attorney given by a trustee. A trustee is responsible for their own actions and is responsible to act on their own in the state of Florida. So a trustee can't give a power of attorney to somebody to sign a deed on behalf of the trustee. They have to do it themselves. And that's why we have great mobile notary services, and we can go to the trustee and get them to sign.
Awesome. All right, two last questions. One sort of in the ballpark here. This is for someone personally. I know this is a little more of an estate planning kind of thing, but how would you handle someone that has a corporation putting it in their will or it being in their will?
So the shares of a corporation are an asset that you hold at the time of your passing. If you want them to go to a specific person, you can identify that person in your will, and those shares will be sent to that person. You can also indicate that the shares will be sold to a third party, and the revenue generated from those shares will be devised to a specific person or as part of the residue of your estate.
Got it. All right. And last one, not related to wills or trusts, but this came up recently. So based on COVID-19, we had an agent who was asked or, essentially forced into.
Ryan,
yeah.
Let me supplement that last question.
Yep.
As well.
Sure.
If you wanted to avoid probate and the shares of stock were the only asset in your estate, then you could also retitle the shares into the name of the person who's concerned about dying with these in their name and somebody else as joint tenants with rights of survivorship. So just like you could put on a deed, you could put on a stock certificate, Paul Krasker and blank Krasker, joint tenants with rights of survivorship. When I pass, it's automatically going to go to that other person without having to go through probate. So if this is the only other asset, you could do that as well. I want to make that clear.
Awesome. And guys, a lot of other estate planning questions, we'll do that as a topic so that we can really just kind of touch on that, because we've had a lot of questions on that. So I'm going to push that to a separate one. One last one about a COVID-19 kind of question here that came up. So we had an agent who was basically forced into disclosing if they had a positive or negative COVID test to be able to show a home. And she brought up a really good point. She sent this email over to Tracy and I. Is that something that they can legally do? Like, there's no way they could ever, force you to say if your client had HIV or something like that. Does that go kind of in that same kind of category with, can you force someone to say whether the sellers or the buyers or one side or someone that's showing or someone that's listing has something?
Yes.
Is that being helpful?
Yes, you can force the disclosure of a positive COVID test, because of the emergency measures that are in effect in the state of Florida, and because of the risk of transfer, then you can require that.
So just to kind of run through that on either side real quick, if you're the listing agent, you could say all buyer's agents bringing someone by would have to show some kind of health or safety report, or?
No, I think it's the opposite. I think you'd have to disclose if you did have a positive test. I don't think you can force people to go get a test before they come look at your property. I think you could force them to take reasonable measures to prevent the spread of disease, but I don't think you can force them to be tested before they come. I think you can force them to disclose, and it would be a breach if they didn't disclose
if you found out
positive
that they were positive. Got it. Awesome. All right, everybody. Well, on behalf of Trident Title, Performance Title and Escrow, and Synergy Title, we want to thank you guys for coming to Better Call Paul. As always, we have lined up next week in the same time slot. We're going to do a live question and answer, and that'll be our last one of those. And then in July, me and Paul have actually planned out 5 topics for you guys throughout the whole month of July. So we'll be sticking with the same time slot in July that you guys can come and join us for. And Monday as well at 11 o'clock, we will be doing our next big training, and that is going to be all about farming. So if you're looking to grow and work a geographic, a demographic, or a psychographic farm, please be sure to join us Monday at 11. Thank you again to Paul, and thank you all for your continued support, sending deals, and please keep them coming in. We appreciate them between all of our companies, and we'll see everybody soon. Thanks, Paul.
Thank you. Bye-bye.
Have a good one.
Thanks.